Hello students, welcome to KANISHKA IAS. I hope your preparation is going well. You are well aware that we have started an initiative where we are trying to decode the concept from the question, because UPSC is repeatedly asking the same concept in the form of different questions, and the questions we are dealing with today is related to Attorney General. If you try to look at the statements, Attorney General and Solicitor General are only officers of Government of India allowed to participate in the meetings of the Parliament. And second one is, according to Constitution of India, Attorney General resigns when government which appoint him resigns. So this is the question asked in the year 2022 preliminary examination. If we try to look at the options here, one only, two only, both one and two, neither one nor two. Let us understand the constitutional position of the Attorney General first before we answer this particular question. Coming to the position of the Attorney General of India, it is a constitutional office which is created under Article 76 of the Constitution. Especially, the Attorney General is appointed by the President, but the one who is advised by the Prime Minister and Council of Ministers according to Article 74 of the Constitution. However, this information is not there under Article 76 Clause 1. We need to presume that he is advised by Prime Minister and Council of Ministers. And the one who is to be appointed as Attorney General of India, he must be having the qualifications equivalent to that of the Supreme Court judge. And the legal advice is given by the Attorney General according to 76 Clause 2. On those matters, the President refers the matters to the Attorney General. And coming to the Clause 3, right of audience in all the courts in the country, and Clause 4 shall hold office during the pleasure of the President. So before we understand the Attorney General, let us understand some basic issues. Let us understand certain basic features. First of all, we have state there are three important organs: legislature, executive and judiciary. Since we are following the foundational principle, that is nothing but supremacy of Constitution. In India, the Constitution is supreme. So in other words, no organ shall be going against the supreme law of the land, that is Constitution. So legislature and executive has to perform their functions within the framework provided by the Constitution, where whatever the laws enacted by the legislature, whatever the rules made by the executive, they must be within the scope of the Constitution, they must be within the principles of the Constitution. But you understand, legislature and executive are not the expert bodies legally. So in order to assist them, the Constitution makers have wisely provided an institution called as Attorney General. So that's why Attorney General is part of the executive. That's why in India, what is executive means? It is a combination of Prime Minister, Council of Ministers, even President, Vice President, including Attorney General. So this is what the significance of Attorney General. Then what are the functions of Attorney General? If we try to look at the functions of Attorney General, these are of three folds. Number one, Attorney General advises government. Attorney General participates in legislature. Attorney General appears or defends the government in front of any court in the country. These are the threefold functions of the Attorney General. Why Attorney General has to advise? Because Attorney General has to advise the government because of certain reasons. Number one, no law or no rules shall go inconsistent with previous laws or previous rules made by the government. Number two, law shall not be permitted to violate the Constitution. So law shall not be violating the Constitution. And number one, no law or rule shall be going inconsistent with the previous laws or rules made by the government. This is the most important aspect. Because he has the knowledge equivalent to the Supreme Court judge, he will be in a position to verify whether the law is consistent with the previous laws or whether the law is consistent with the Constitution or not. So that function he actually performs. Moreover, Attorney General also participates in the legislative proceedings. Especially Article 88 of the Constitution permits both ministers and also Attorney General to be present in front of any house or any committee, or even be participating in the joint sittings of the both houses, Lok Sabha and Rajya Sabha, but without any right to vote. Attorney General will not be having right to vote in both of the houses, but minister may be having right to vote in one of the two houses. So this is what Article 88. So why Attorney General shall participate? Why Attorney General can participate? Why? Because Attorney General, being a legal member or legal expert in the legislative and constitutional matters, he is in a better position to advise the legislature also regarding the constitutionality of certain issues. For example, when the bill is introduced into Lok Sabha, Rajya Sabha, when at the time of introduction of the bill, that is at the stage of first reading, if any member raises the competency of the legislature to enact the law on that particular subject, then the Attorney General can appear in front of the House and give the clarification. Moreover, you are able to see most of the bills passed by the Lok Sabha and Rajya Sabha are generally belonging to the category of public bills. So naturally, these public bills are nothing but these are the brainchilds of the government. So government can use the Attorney General office to convince the legislature to understand or to accept the competency of the legislature to make the law on the particular subject. So that is how he does. And thirdly, government is one of the biggest litigants in front of any court in the country. More than 50% of the cases are related to government itself. So government wins or loses the case, it will be having very greater repercussions on the government. So hence Attorney General can appear in front of different courts. In this process, he is assisted by Solicitor General and Assistant Solicitor Generals. According to this doctrine, any law enacted by the legislature, any rule made by the government shall not be invalidated by the court unless these are challenged. This is what called as doctrine of presumption of constitutionality. So it is very much possible because the government is being advised by a legal expert called as Attorney General. So because of his legal expertise, the governments are making rules and the legislatures are enacting the laws in a foolproof manner. However, any law can be subjected to judicial review, but most of the occasions, the law will not be invalidated by the court so routinely. So that is due to the contribution of Attorney General. Moreover, Attorney General has another important function with respect to Contempt of Courts Act of 1971. According to this act, if any person, indulges in the activity of contempt towards any court of the country, if he has to be punished by the court, or if this petition has to be filed, that is contempt proceedings or contempt petition is to be filed in the court, that can be done in two ways. Number one, A is through suo motu basis, and second one is through on the basis of consent given by Attorney General. So if any petition is to be accepted by the court, either the court must have voluntarily taken up the case, or the court must take the petition which is consented by the Attorney General. So this is also an important role played by the Attorney General. In this particular situation, Attorney General plays the role of a tribunal. That is nothing but he acts like a quasi-judicial body. Attorney General holds office during the pleasure of the President. That is given under Article 76, Clause 4 of the Constitution. So it means despite government resigns, as long as he holds the pleasure of the President, he continues to be in the office. The same rule applicable in the case of governor as well. Governors also do not require to resign when the government changes. Rather, the President has the power to continue or discontinue. This is what called as pleasure of the President. But however, the pleasure of the President is governed under Article 74 of the Constitution, where President does not have the discretionary power, rather he has to act upon the aid and advice of the Prime Minister and the Council of Ministers. Then coming to Solicitor and Additional Solicitor Generals, they are the law officers recognized under Law Officers Conditions of Service Rules of 1987. In fact, they are not constitutional bodies, rather they are called as statutory posts. Statutory post means it is a post created under statutory rules. What is statutory rule? Statutory rule is something where these rules are approved by the Parliament by means of a statutory resolution. So hence these are called as statutory posts. right? And these officers will be assisting the Attorney General in the discharge of his functions. They can also be appearing in front of Supreme Court or High Courts whenever Attorney General is not available. So that's how these are called as law officers under Law Officers Conditions of Service Rules of 1987. But you understand, Attorney General and the Solicitor General do not have the equal status. Attorney General is constitutional body, rather Solicitor and Additional Solicitor Generals are not holding any constitutional position. And moreover, these are the creation of the statutory rules made by the Ministry of Law and Justice. Moreover, Attorney General, that is, and Solicitor General differ with respect to a right to participate with respect to proceedings of the legislature. Second one, the power to give consent on contempt proceedings or petitions. And coming to third point, parliamentary privileges under Article 105 of the Constitution. These three aspects are related only to Attorney General but not related to Solicitor General. Only Attorney General has a right to participate in the proceedings of the House. Only Attorney General has a power to give consent on the contempt petitions. Only Attorney General is provided the protection of, under the parliamentary privileges, and also Attorney General is the only one officer who is able to give legal advice to the government according to Article 76 of the Constitution. So after going through all these details, it is very easy to answer this question. So it is very easy. Now you look at these statements. So Attorney General and Solicitor General are the only officers allowed to participate in the meetings of the Parliament. So here what is there? Solicitor General is there. Hence the statement is wrong. According to Constitution of India, Attorney General resigns when government which appoints him resigns. This is wrong according to Article 76 Clause 4. So this is also wrong. So hence the right answer is D. This is how we can easily answer the questions if we know the concept. For more concepts, please subscribe to KANISHKA IAS. Thank you.